Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We have been monitoring the docket in Ada County for some time to see if there has been any post-conviction relief petition that has been filed by Mr. Kohberger under the law that would allow him to move for such relief if he ever intended to do so, and that is the Uniform Post-Conviction Relief Procedure Act, which is a statute. It is codified commencing at section 194901. This is Idaho Code, Title 19, Chapter 49. In the district court where they were convicted. In this case, he was convicted. He was sentenced in Ada County by Judge Hippler on July 23rd, 2025. There are grounds that would authorize someone to challenge conviction or sentencing under the statute. Again, that's 194901. And the reasons are codified there. Generally speaking, in the state of Idaho, a post-conviction petition operates as a completely different action from the original criminal case. Under the portion of the statute 19-4902, an application must generally be filed within 1 year from the expiration of the time of judgment. So this operates as a strict statute of limitations with respect to a post-conviction relief action in Idaho. If Mr. Kohberger ever intends to file one, it must be filed in Ada County, even though this case began in Latah County. Why? Because that is what the statute clearly and unambiguously requires. Now, in such a case, he does not go to the appellate court. He does not go to the Supreme Court of Idaho. He files the original proceeding in district court, Ada County. As the petitioner in this action, he would bear the burden of bringing forward facts, giving a prima facie case, showing that he would be entitled to even seek such a remedy. Sometimes these cases are dismissed at the initial stage because the petitioner does not bring forward sufficient facts. One grounds that the statute would allow for such relief is that, for example, the conviction or sentence violated the United States Constitution or the Idaho Constitution. So as the petitioner who's looking for this remedy potentially would need to bring forward facts, point to the record at the time of sentencing and conviction where this error is, possibly attach affidavits and the like, because it is the petitioner's burden to show at this initial stage that he or she is even entitled to any relief. There would be a new case number that's attached to it with the defendant. Here it would be Mr. Kohberger listed as the petitioner, while the state of Idaho is the respondent. Why? Because he is seeking the relief. It's not the state of Idaho who would be looking to have the sentence or conviction set aside. He is looking for the remedy. He would be the petitioner, just like EWU Media is the petitioner in the EWU Media LLC case that has been brought against the city of Moscow and the Moscow Police Department, or last year when the petitioners in Laramie et al. Brought an action as petitioner against the city of Moscow. As of right now, July 4th, 2026, there is no indication of any post-conviction relief action filed by Mr. Kohberger in Ada County or anywhere else for that matter. We're going to continue to monitor the situation. If and when any petition for post-conviction relief is filed, we will, of course, advise you. Please stay tuned to the Indie Zone for further updates. Until next time, thank you for joining us here today.